Hi, I'm attorney Andrew Thomas. Welcome to the Deposition. I'm joined today by our attorneys, Blake Allen,
Hey, everybody.
senior attorney Nathan Lewis.
Nice to see you.
How we doing, fellows?
Pretty good.
It's a good day.
Good day.
All right, ready to talk some immigration?
Absolutely.
Always.
All right, let's do it. So one of the topics that we're getting a lot of, and obviously we're seeing in our own practice, is detentions. So people being detained out and about in the community, which is scary in its own right. But the new thing that we're starting to see, and we've talked about it a little bit, is people being detained when they go to immigration court. They're actually showing up to their hearings, and right after the hearing, being detained by an ICE officer. I know you've seen this.
I have seen.
Yeah, well, you've seen this.
Yes.
We've seen this. Can you guys talk a little bit about what you've seen and who this is affecting?
Yeah. So, from my own personal practice, who this is most commonly affecting are people who have entered into the United States within the past 2 years, and especially single men going to their court dates. Those are the two most common targets of this practice.
So, I mean, we could speculate a little bit as to why that is. Obviously, this is a new policy by the new administration. Um, when they're targeting men, and we can move into another topic that we're going to talk about, is when people are detained, what their rights are. And obviously, there's a bond process in immigration, just like there is in the criminal side of things. And when they go into bonds, they look at certain things. They look at, ties to the U.S. and those things. You want to talk a little bit about what we see on bonds?
So in bonds, like they were looking for good moral character. The foundational argument is: are you a threat to the community? If you have, or if you have ties to the community. So what that means is, like, if you have a U.S. citizen spouse or resident spouse, children that are U.S. citizens, that goes a lot longer into them granting you a bond, because you're not a flight risk. You're going to stay and fight your case, and they want to make sure you show up to court.
Yeah, they're also looking at, Blake, as we talked about, they're also looking at the strength of whatever application you may have.
Yeah, absolutely. So that's one of the factors that they do consider. So if they think that you have an application that is unlikely to be successful, they're less likely to grant you a bond, because at the end of the day, one of the processes for immigration court is to determine whether or not you're deportable. So if they don't think your application is strong for whatever reason, then that increases the chances the judge would deny a bond.
And they're also looking at factors like if you were detained for a criminal matter, right?
Yeah. So traffic is not as big of a deal. Traffic offenses. However, if you have any serious criminal offenses, even like DUIs is a serious criminal offense now. It makes it much harder to get a bond. Um, they automatically assume right now, here's a DUI, domestic violence, assault, anything that's a major crime. You're a threat to the community. You're a danger. You're going to be detained while they hear your case.
And then, due to the Lake and Riley Act, which we all know passed earlier this year, any theft offenses means you're no longer eligible for a bond statutorily.
So let's talk about the process of a bond. So someone that finds themselves detained, whether they're detained when they went to immigration court, they got picked up at a job site on a raid, or they got arrested and they've been moved to the immigration detention facility, the process of a bond. So they come to see us or an immigration attorney. What's that process look like?
Yeah, absolutely. So whenever you come and retain somebody for a bond, it's a pretty straightforward process. Most of the time, your case at that point is going to be an electronic file with the courts. So then your attorney, whomever they are, will be able to compile a document from you getting evidence, such as, proof to community, all the factors that Nathan just covered earlier. We assemble that plus some legal arguments and file that with a court. Typically speaking, your bond hearing will be set within usually 2 to 3 weeks at maximum of the filing of the bond request.
And so at that bond hearing, you're making these equitable arguments to a judge as to, why your client, the respondent, should be granted a bond. Ultimately, we know it's up to a judge whether he wants to grant or deny. And then if he does grant, at what amount he's going to set that bond out.
Yeah, absolutely. And, at the end of the day, the judge has wide discretion on if to grant a bond and what amount to grant a bond. Under this current administration, bonds that are being granted are a little bit higher than they were under the Biden administration, but bonds are still happening.
And so if somebody is granted a bond, what would the family do at that point?
Yeah, so the ICE has a way for you now to be able to pay your bonds online called ICE bonds. You can do it all online. You pay the fee. After paying the fee within 24 hours, the facility should then prepare your relative, friend, whomever for release. You can then pick them up from the detention facility, or oftentimes they'll just get a bus and head to wherever their home is at.
So then when they're released, they still have immigration court, obviously. It just goes on to a non-detained docket, as we know. They'll still receive a notice of hearing for, say, a master calendar hearing. Likely would be the next step, but it'd be a slower process, obviously.
Yeah, absolutely. So typically speaking, if you are in detained court, your case lasts probably maximum about 6 months. If you are non-detained, it can take multiple years.
And so the detained one would be obviously somebody that was not granted that bond. Either they couldn't file it in the first place, or they did file it, they were denied, they remain in detention, and so they're still entitled to an immigration court case, just on this detained docket that's going to be what we call a rocket docket.
Absolutely.
So, and kind of to expand on point that Blake just made is that it is very crucial for people now with the bond issues to contact attorneys very quickly after they arrive in the country. And in the past, people would arrive in the country, they would get a notice of a court date, could be 2, 3, 4 years in the future. They would wait to file their application for asylum. If you don't file your application for asylum quickly, your case becomes what's called withholding of removal. If you file your application after a year, that's a mandatory detention with ICE. So you want to contact an attorney very quickly after you arrive in the country in order to make sure you have everything properly filed to decrease your risk of being detained by ICE.
It's great advice. So one recent thing we've seen in the last couple of months is the recalendaring of dormant or even administratively closed immigration court cases. People that maybe haven't had a hearing in 2, 3 years, maybe longer, had their cases either administratively closed by an immigration judge, or an immigration judge just took it off the docket and the case has just been dormant. Now they're starting to get these motions to recalendar or even just a new notice of hearing, essentially resetting their case. I know you guys have seen this.
I deal with this every day with potential new clients or some of our old clients where they may have been here for years with an administratively closed case or a case that's just no longer active with the court. All of a sudden, they are now placed back into court at the initial presentment phase. Essentially, it's just the court just restoring a brand new case against the person.
Yeah, so that's essentially resetting an immigration court case. And whether they had an individual coming up and it was taken off the docket or something, now they're essentially getting reset to the master calendar stage. And, you know, we could say fair or not, but a lot of circumstances may have changed in their lives in the last few years. It's going to make it somewhat difficult.
Yeah, because I mean, at that point, like if it's been years since your case has been open, the facts of your case may be stale. If it was based off a familial relationship, who knows what's happened in your own personal life, divorce, death, whatever, like your situation could have changed at that point. So
But also to the positive that if it's been years since your case was closed with the court, you may have new family relations in the United States that may give you other opportunities for relief in court or outside of court. So there's good and bad to this process.
I think the key and what you were talking about there is being proactive always beats just being reactive. So if you do see this and you're getting recalendared or your case is being reopened from an administratively closed case, taking action on it is going to do nothing but benefit you. Just sitting there while they're taking all the action, because they are moving for a deportation at that point. It does not behoove you to just sit back on your laurels at that point.
yeah, and
No.
an immigration judge will also appreciate if you take action on your own case.
Fortune favors the bold. So one frequently asked question and thing that I see in consultations or even with clients are, when can they travel? So they have an application pending. Now they want to travel. What are the rules here? If somebody has a work permit or otherwise a pending application, what's the situation?
So it depends. By travel, if you're talking domestically, that's different than internationally. If you just have a work permit does not allow you to travel outside the country with a work permit. Now there are certain applications you may qualify for, mainly called advanced parole, which is the government agreeing to allow you to leave the country and come back in. But if you travel while you have a process pending without that pre-approval, you're not coming back in the country.
And advanced paroles are only allowed under limited circumstances too. There's only a couple of different processes that would allow for such a thing.
And if you do leave the country while you have a pending process, for most processes, the government will then consider you abandoning your process and you will be stuck outside of the United States.
Right.
So dress codes for interviews with immigration. This is a topic that I hear people talk about. It's not really thought of that much, but it is something that does come up. What should people wear when they're going to see an immigration officer after maybe years in a process? They're finally getting their big date. They're going for their interview. They could be grant or deny their application for residency. What should you wear?
So technically, there is no official dress code, but that doesn't mean you should not treat it like a job interview. That's what you should do. Like wear business casual, or don't. I mean, I would advise against showing up in like shorts and flip flops. Just treat it like you would go to a job interview, or maybe when you work shirt or something like that. I mean, something like that.
Because at the end of the day, discretion matters in every single immigration process.
Right.
You want the person deciding if you should stay in the United States to think that you would make a good citizen of the United States at the end of the day. If you show up in crop top and flip flops, they probably won't think that.
Your hearing officer has great discretion to approve or deny your case. So you will put your best foot forward when having your interview.
So you're talking to a human after all, right? This might be the first or only human interaction you're going to have in your entire process. So they're going to be not only viewing your application, but viewing you as a person. And people are people. They make judgments on what they see. So dress for success to have your best chance at it.
Absolutely.
All right, rapid fire. Give one tip for somebody that's going to an interview and what can help them prepare for success.
So I think that something that is going to make you feel good in your interview is taking care of yourself. Before your interview, take a shower, brush your teeth, basically be clean, ready to go. You're going to feel more confident, and the interview is probably going to thank you for smelling better
Probably a good advice any day, right?
every day of the week.
How about you?
I would say be honest. If they suspect you're lying about something, they will, best case scenario, not approve you and then request more evidence from you to prove your point. Worst case, they would deny you or issue a notice of intent to not deny you an interview.
And I would say review any and all applications that have been submitted for you. And what's in there, it's good to know what's in front of them. They're going to have your file out there. It's good to review those things. Do you need to know every single comma and period in there? Probably not, but it is your story and you should be familiar with it.
And just realize that the hearing officer is not just taking your word or your attorney's word at these interviews. They do their own independent research into your life.
All right, so before we leave, I want to get back here because you guys are in the trenches. We're all out there practicing law. Let's highlight some success that we've had. Let's leave on a positive note here. Attorney Blake?
Yeah, absolutely. So recently, the government has been setting a lot of interviews for family petitions at USCIS offices. A couple of weeks ago, we had a contested family petition that I went to the USCIS offices and assisted with. We were able to get our client's I-130 approved despite some questions from the government about some validity of the marriage going on there. And we were able to allow our client to move on to the next step in getting her residency.
That's awesome. How about you, Attorney Lewis?
So one thing that we should touch on earlier was being detained at your master hearing by ICE. One thing we've had great success at is we file motions to vacate these hearings, and that means you don't even have to go to the courthouse on your hearing day. Like we take care of it for you, so there's no risk of being detained by ICE at your hearing.
They can't detain you if you're not there.
Right.
Absolutely.
And I just want to highlight another big victory that this firm has. Because we do fight for them. We all fight for our clients. I mean, when people come into our firm, it does mean a lot to us. Their success is our success. So we did have a client that was detained, and I know you guys are familiar with where I'm going with this. We had a client that was detained. We did file a motion for a bond. It was granted, which is great. The family then posted the bond, but the respondent, our client, was then transferred to another holding facility where ICE essentially refused to release him, even though we had a granted bond. We had to get on the eve of filing a motion for habeas corpus, which in legal terms is a pretty serious motion to have somebody released from custody. Thankfully, that kind of did the trick without us actually having to take that unusual step, and they were released. But ICE is serious about this stuff. So again, you got to be proactive. You've got to push the government to do what's right.
And I'm glad we were able to do that there.
Thanks for joining us today on The Deposition. Thanks, Attorney Blake Allen. Thank you, Attorney Nathan Lewis.
Thanks for having me.
Thanks for having us.
See you guys on the next one.
Yeah.
See ya.